Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
So today we got Andrew Robb joining us from the great state of Missouri, who has found his niche with his family in the aircraft collision crash catastrophic business. So how are things going in Kansas City? Because I'm in New Orleans for the Southern Trial Lawyers Conference, and it's fucking freaking freezing down here. So
happy to be here, Dan. New Orleans, it's pretty sour right now for Chiefs fans. We were just down there for the Super Bowl, and I'm still licking my wounds, brother. It was ugly, and Philadelphia Eagles fans are not the friendliest. We were trying to be nice to them, because they won and congratulating them, and they wouldn't have it. We were on the way out, saying good game, way to go, and they said, "You don't get to tell me that," more colorfully. Not the best experience for us, but we've had a good run the last.
Yeah, I think 2 Super Bowls in a row is enough.
Yeah, we're
one city.
We're lucky. We're so lucky.
For one city, that's enough. So you're fortunate enough to work with your family and have them have a great firm before you went to law school. So how did your parents get into the aircraft crash business?
So, they founded the firm in 1984. They also, like me and my wife, started on the defense side. My dad and mom both were at big law firms in Chicago, and they just didn't like it very much. They both have their stories of what they didn't like about it, and they moved back to where they're from, Kansas City, and started a husband and wife PI shop. And they started out doing everything. They tried tons of cases, right? And I think it was maybe the early 90s or late 80s, they got their first air crash case, and they did well with it. And then that led to a case they got in, I think, 1993 that was tried here in Jackson County, Missouri, and got a $350 million verdict on it, which I think is still, I know it's made the largest aircraft verdict in U.S. history, I think. And that just launched them into the stratosphere, I think. And, they kept getting aircraft business. That's kind of how it started.
All right, but you've been with them for a few years, but you didn't always want to start out to be a lawyer. So what were your initial plans?
Yeah, so I grew up, I was kind of a musical kid. I was a theater kid. Actually went to college to do vocal performance. I was going to be an opera singer. That was my thing. Carnegie Mellon in Pittsburgh is where I went to school. So a little bit different than the law. But looking back, I think there are lots of things about performing on the stage that relate to being a trial lawyer.
I mean, they're so connected. People talk about, friends of mine talk about taking acting lessons to become a better trial lawyer. And I'm like, it's not a bad idea. I mean, if you're doing something where you're being intentional and you're performing, that's good. But, being a trial lawyer is a lot more like being a stand-up comedian than it is being an actor. Because
absolutely agree. Absolutely agree.
Right.
And there are things that about vocal performance that I didn't expect to be so influential in my trial lawyer, practice. Being a singer is a lot about breath control, And sometimes, I think when you get nervous, you tend to lose control of your breath. So when you're getting up, in a trial, in a high stakes situation, I think it is very incumbent upon all of us to be very cognizant of our breath. And that's one thing I still go back to. Before I get up, whether it's a motion in limine argument, an appellate argument, to cross someone, to do voir dire, I am always thinking about, make sure my breath's very present and strong. And that's something that goes back to, vocal performance.
But when I do my coaching and I do my boot camps and stuff, one thing that I've observed and, because we record people, it's like people don't breathe. They pause, but don't breathe. They pause, but they don't inhale. If you don't inhale, you run out of air. Plus, inhaling creates a little bit of space for the mind of the audience to actually process and retain the information you're giving them. Right. But people won't do it but when they get nervousness and, the courtroom's a very stressful situation, but, the training room is a little stressful, not nearly as stressful as a courtroom. But if you can't learn to breathe properly there, it's going to be hard to do it right when, the rubber meets the road in the courtroom.
Couldn't agree more.
It's about practice. So practicing. So you start off to be an opera singer. So when did you decide that, this opera Because I can't imagine the opera singing would pay extraordinarily well unless you were like Pavarotti or something.
Unless you're Pavarotti, pretty much. Yeah, it's a tough life, like, so my first 2 years of college, I mean, it's not like you're a violinist and you can put your instrument in the case and go out to a bar, like vocal performance people are extremely sensitive about talking loudly. You can't have milk ever, no tomatoes. Going to a sporting event, people can't do that because you're talking too loud and this is your livelihood. So you can't, when you're performing on a 2-week stint at an opera company, when you're not singing, you are in your room, breathing steam and reading your music, period. It's a difficult life, right? So that's, of course, one factor. It's traveling around a lot. Opera it's a difficult way to make a living. So long story short, my junior year, I switched my major to be a pre-law track. And I'm glad I did. I took 2 years off after college to work as a paralegal in
Really?
DC. Yeah.
And what type of firm?
It's called Kroll and Mooring. It's a big law firm. They had a good program for kids who wanted to take the LSAT and go to law school. So that's what I did.
2 years of being a paralegal on what kind of cases?
Oh man, it was just the biggest case I worked on was for a Japanese auto manufacturer that was being investigated on antitrust violations. So, I mean,
2 years of paralegal, and then where'd you go off to law school to?
I went to Michigan Law School, Ann Arbor.
That's right. That's a hell of a law school. I went to the
Go blue,
university.
baby.
That's where I grew up in Michigan. I did Michigan undergrad, but not quite Michigan Law School, Detroit College of Law. A little bit of a downgrade, but Michigan Law School, from my limited knowledge of it, really only turns out big law people that work in New York and on Wall Street. So how'd you get out of that trap?
That's a great point. I have lots of thoughts, I think, on the way that law schools that are ranked, whatever that means, in like the top 10, how they turn out their students and what they encourage them to do. But man, I went to big law. I clerked for 2 years. Then I went to big law for 2 years because that is kind of what my law school encouraged everyone to do. And there are lots of reasons for that. The big law firms come in from day one and they're whining and dining first years, and then you have on-campus interviews at the beginning of your second year where all of the big law firms come to Michigan and they interview all these kids and everyone's talking about, how the interviews went. It's that like everyone's, oh, what did you get? How'd that go? And then you get your offers and then you have your 2L summer job. And then, it's kind of the way that the law school is structured. The dining hall at Michigan is Kirkland and Ellis Dining Hall, right? It's just the way it worked. So that's what I did. I had my big law job before graduating 3L year, and then I went to clerk for 2 years. But that was my track. Even though I grew up with two parents who were on the plaintiff side, I think I wanted to get out there a bit and see the legal field from different perspectives before deciding to come back.
You said you had an offer from big law in your 3L year, but then you did 2 years of clerkship. So tell me about the clerkship and how that helped shape you and what you learned there.
Yeah. So my first clerkship was with Dwayne Benton on the 8th Circuit Federal Court of Appeals. He's the man. I mean, awesome, really good judge. George H.W. Bush appointee, longtime federal appellate judge. And he is a guy who takes his mentorship role with his clerks so seriously. He's an appellate judge that I think all practicing lawyers would want because the man analyzes the facts and the law in the way that he thinks the law requires. He has no agenda, and he does what really all lawyers expect from a judge. And on top of that, he was so awesome in terms of helping writing skills, so every opinion we would draft, he had a standing desk in his chambers, and we go in there, and he would go with us word by word through all of our opinions. And he would he would explain why he thought the opinion should be drafted in certain ways. And I still to this day think it's really important to be clear and pungent and really striking in your writing. That's really from him. So that was really awesome. And my second clerkship was with a federal district judge, Greg Case, of the Western District of Missouri, and another awesome guy, much faster pace on the district court level, but learned a ton from him too.
So you got these 2 clerkships under your belt, and then where do you go for your next career move?
And then I went to New York City. My wife and I went to New York City. We both worked in big law. She worked at Debevoise and Plimpton, big New York firm, and I worked at Boyce Schiller Flex for 2 years. That's what we did there, and it was a grind, man. It was a grind, but it was great to see what that was like.
What kind of cases did you work on there?
I worked on behalf of a large bank that was being sued for fixing the gold and silver markets.
Well, those kind of lawsuits wouldn't exist anymore in today's, Washington, fixing markets,
Right.
rigging things. None of that's
Yeah,
illegal anymore. And if anybody tries to prosecute them, they'll get kicked out of office. So
that's right. Or the prosecutors will resign.
exactly. And so there won't be any of this kind of work for big law. So everybody,
Exactly. So I don't know what my former colleagues are doing when none of this stuff's being investigated anymore. Right.
yeah, it's fascinating.
Yeah. It was different. It was a great experience, but I think I learned a lot from my colleagues. I have nothing bad to say about them really, but I think my issue really is with the structure of how big law firms work. You're billing by the hour, and when you're living your life, every 6 minutes you have to bill something. You have a target. When you're living your life in this way where you have to, imagine going back after a day and thinking about what you did and putting it into a platform where you're putting everything in, to a code that gets billed to the client. And people do that in different ways, right? You have timers. Some people, do it by email, but inevitably sometimes like you have busy days and you get behind, and then you have to go back and you have to think about, oh God, it's Friday and I didn't bill because I was, working a 100-hour week. And, what did I do on Tuesday? It just messes with your brain, in my opinion.
How many hours do you think you were working a week during those days, during those 2 years?
I don't, a lot. Probably, the billable hour requirement was 2,000. So 2,000 hours a year, I don't know. On average, I had a couple 100-hour weeks, which is big, but, we worked a lot. They wanted you to work a lot, because that's how they got paid.
That's how they make money.
Yeah, and my wife actually, she has some crazy stories because she worked on behalf of the Sackler family of
Really?
opioid, like
Oh,
the family.
Oh, I know who they are.
So she got absolutely smoked for 2 years by them. They're billionaires, and they had all these different lawsuits to defend from all these different jurisdictions around the country who were suing them for the opioid crisis. It was a situation where she had to have her laptop next to her while she slept, for a time. And we went on like a vacation with some friends to Vermont, and she just wasn't there. The team was working. I remember going to a brewery one time, and she was in the car the entire time because the rest of us were having fun, and she was billing away. It's not the quality of life or the quality of clients, respectfully, that we wanted.
No, I think we can all agree that the Sackler family is not the kind of people that you want to put your blood, sweat, and tears in representing, defending, trying to protect their wealth.
Well, they're making a lot of lawyers a lot of money.
Yeah, but they're killing a lot of people simultaneously,
Yeah,
or they've killed thousands. So many. I don't know how these people live with
yeah, I don't know.
Don't know how people live with themselves actually. But so 2 years of this. What was the best part of working at Boyce Schiller? I mean, because it sounds pretty prestigious. Everybody's heard of David Boyce.
Yeah, David Boyce. So I think the best part, the most interesting part was I had the office right next to David Boyce, and I didn't actually work with him, but I just got to know him by being in the office next to him. And he's just a really cool guy, very hard worker, and it was cool to see him into his 80s, still very active practicing and still leading the firm. There have been some public things that have come out about, people leaving that firm and starting other firms and, because of some things that David did. But my perspective of him was just a really hardworking guy, obviously a legend for the stuff he did with Microsoft and the gay marriage case. But it was just cool, being a part of that firm and getting to watch David work a bit.
And what was the worst part? Everybody says billing
hours. I don't want
hours.
to go on too long here. Well, billing hours, and there's this whole culture in big law. How do you get your moral rocks off in big law? Because no one thinks that representing big banks is morally satisfying. And the way you do it is by doing pro bono work. And so going, to like a charity pro bono gala in New York City with a bunch of lawyers is a fascinating experience because the people being honored are always, big law partners who get lauded for dedicating all their time, a large portion of their time to some great pro bono cause. But it also turns out, that the partner is writing big law, and their biggest client is Enron. The pro bono aspect of big law is really pushed and emphasized as a way for younger lawyers to feel morally satisfied. That's what I observed. And I thought, hey, is there a way where my Enron, my big bank, go-to clients can be clients that I actually feel good about, right? Is there a way to do that? And that's kind of how Brittany and I started thinking. And, my parents had this really successful practice back in Missouri. And by gosh, they have the privilege of representing clients that they actually believe in. All of them, not just the pro bono ones, all of them. And, that's kind of how our conversation started about, hey, maybe we should ask my mom and dad if we could join their firm.
And I'm guessing that you did, and they said yes based upon your current position.
That powers of deduction, Dan. That's why they pay you the big bucks.
That's right. That's why I get to be the host, because I'm
that's right, baby. Yeah.
So astute.
Yeah.
So astute. So
that's
Andrew,
right.
Andrew, you're a pretty young guy. How old are you?
36.
36. And how long have you been at Robb Robb?
Our first day at Robb Robb was March 16, 2020.
March 16th. Going on your 6-year anniversary almost. That's
coming up on 5 years.
5 years, yeah. March 16,
2020 was like the day of the lockdowns.
Might have been the first day, or right within a day or two of that day was the first time that I broadcast a webinar on trial lawyers. It was called case analysis back then, but now it's Trial Lawyers University. So
look how far we've come.
See that? 5 years of...
We share an anniversary.
Yeah, of relentless work.
That's right.
And so in your 5 years there at Robb Robb, or even before that, what would you consider to be the professional accomplishment that you're most proud of?
Oh, man. That's tough. It's been a whirlwind 5 years at this firm. When we joined, we had just been retained by Vanessa Bryant in the Kobe Bryant helicopter crash, because that crash happened in January of 2020. And the lawsuit was filed in February of 2020. So I don't think I can just glaze over that. I mean, it was an honor to represent, her and her family in that lawsuit, which kept us quite busy for much of my first year and a half at the firm. And then, as kind of COVID broke away, we started to get back to a normal flow. We've had a couple cases in the past 2 years that have been highlights, but I mean, the highlights, man, are the moments with your clients after a good result. You can't recreate that moment. Now, we had a 3.5-month trial in New York City last year that I don't want to talk too much about because it's still on appeal. But man, it was a great verdict after a long, hard fought battle in New York State with our client who lost her son in an aircraft accident in the East River. And that moment after the jury came back and we all, hugged on the plaintiff's side, it was just so overwhelmingly emotional to be a part of her battle and the success like that. And frankly, man, I'm addicted to it. I'm addicted to being a trial lawyer. I really am. I think a lot of us are.
There's no doubt about that. Like Panish is doing an opening statement today on a products case. And I mean, he's got more money than he can spend in 20 lifetimes. Yet he's still, and I talked to him last night, he's under the weather, but he's like, Ambrose, you think I'm not going to answer the bell because I got 105 temperature? No, I'm going to go to court and I'm going to handle business.
We all know it.
And and like Rowley, all these guys, they just got freed. They got endless money, but they're still looking for that trial, looking for that battle, looking for that next, I think it's a lot has to do with the competition of it too. I mean, obviously there's a fulfilling reward. Obviously there's money, but it's the competitive spirit of like a 3-dimensional high stakes chess game where you have to like out strategize and perform physically.
It's a drug, man, and I can't get enough of it. And my parents are really, of course I'm biased and I think the world of them, but they're in that same boat, man. They could have retired, a long time ago, and they ain't going nowhere. They are as vibrant as you could possibly be, and they want more.
Well, hopefully you're going to bring them out to Huntington Beach with you so they can see what the world's greatest trial, it's not even a conference, an event, because they call it a conference. People mistake it for their state trial lawyers or any of these other national conferences, which it's nothing like. And
Right.
so, I mean, because it's nothing like it, because it's the fourth year. I think Rob, Andrew, we got it dialed in so that Rob and Rob can appear this time though, because
We're ready.
after 4 years of practice, because now we buy out the whole hotel. We have, a full breakfast, a full lunch for everybody every day outside. So that's great for network and making friends. We got 8 workshop tracks, 4 lecture tracks with, the greatest trial lawyers are coming, like, Brian Panish, Nick Rowley, Randy McGinn, Joe Freed, Satch Oliver, and the greatest trial consultants like Eric Oliver, Sari De Lama, Philip Miller, Jessica Brilo. So we just got a lineup from, Ben Rabinowitz from New York. He's, another inner circle guy, super guy teaching expert witness cross-examination. And then Nick Rowley's going to do a 1-day TBI masterclass because he's really got some great results on a variety of TBI cases. And
he's an absolute stud, for sure. I like a lot of all the stuff he's done and the publishing he's done, to help other lawyers.
Right.
Really great.
Yeah, he's a great guy too. Oh, and my friend David Clark, who is my mentor from Omaha, who taught me about the unconscious mind and conversational hypnosis by, Erickson and NLP, and applying it all to structuring not just openings and closings, but just, questions in voir dire. And actually, we've taught a few times this program called the Dark Arts, where he works with people on framing their case. And I work with people on their, presenting and performing their case. And so we're actually doing a 4-day Dark Arts program, May 31st through June 3rd in Huntington Beach.
Right before the conference.
Yeah, right before the conference.
The
gathering.
Not a conference.
Not a conference, right. But it's an event. It's a trial lawyers event.
There you go.
Unfortunately, that 15-person boot camp is sold out, which makes me very happy because, when I come up with ideas that are going to help people, just because I think they're great doesn't mean the world thinks they're great. But I only know if they think they're great or not if they decide to show up and participate in my little party called Huntington Beach, because I had this dream years ago before I did the first Huntington Beach, like to create a really kick-ass beach party for trial lawyers to start the summer off, because, the summer's great in California, and, this job is, it's a tough job. So it's, that's why conferences, I think, need to be fun. Oh, because we have themed parties every night too, which I think, we've been doing since we started. And our parties are 3 hours long. They're not just an hour. And about probably maybe a little over half the people get a little dressed up, because we're going to have an Elvis and Marilyn party. We're going to have a disco 70s party. And then the third one, we put out a survey yesterday, because it's either going to be like a Pirates of the Caribbean or maybe like a Revolutionary War theme. That's going to be a little more difficult. We like to make it not too difficult. And so, to make this, you get it too difficult, it gets too complex. Oh, then superheroes and villains. So those are the possibilities, but we'll see what happens there. But with the live band karaoke, you're going to really be able to shine. So
I'm ready. Get a couple cocktails in me, and who knows?
I'm sure you want to be.
My lawyers like to have a good time.
The highlight of TLU for me was having the opportunity to network with attorneys from out of state.
TLU's been amazing. I'm so glad I came. It was one of the most inspiring events I've been to. Great networking, great food. It's been amazing. I can't wait for next year.
So you're going to be teaching a workshop and doing a lecture in Huntington Beach. So what's the workshop going to be on?
So the workshop is going to be on the aviation case. Aviation is a very growing, ever-growing, and large part of the American economy. There are lots of aviation cases out there, lots of aviation lawyers, and lots of aviation crashes, as unfortunately, I think the world has seen all too well the past few weeks, right?
Oh, yeah. Disaster at, D.C., and then the plane flipping over. That's just crazy. The plane can't land in snow.
I know. It's wild. And, aviation cases are inherently complex just for a number of reasons. One of them is don't get your primary source evidence until the NTSB is done with it. Like for every single general aviation and commercial aviation crash that occurs in the U.S., the federal government seizes control of the crash, of the wreckage, until they're done with their investigation. So what we have to do as plaintiffs' lawyers is we have to work with secondary source evidence, videos, expert analysis to figure out if we have a case, because oftentimes they're holding on to that wreckage until the statute expires. If you crawl into a court when the statute expires and says, hey, I don't know if I have a case because the federal government still has the wreckage and I can't get my experts to see if there was a products failure, you're too bad, right? So, we have lots of different ways of figuring out how to meet that plausibility burden without actually being able to look at the evidence. And then there are lots of just federal and state issues and regulations that come into play. You're going to get some immediate motions to dismiss in aviation cases that you got to deal with. Preemption is one of them. Applying a federal standard of care, so you got to be prepared for those. And then when aviation crashes happen, it's probably not a broken arm, right? It's a severe and serious injury, and it's immediate. It's not as if you have a medical diagnosis and you're prepared. And so the families that have victims who've been affected by aviation incidents are always just going about their day, and then boom, and so how do you frame sudden trauma like that to a jury? And just we have different tricks that we've used. Pre-impact terror too, how do you deal with that in an aviation crash? Just lots of different idiosyncrasies in the aviation crash that we've employed over the years that we're anxious to share in your workshop.
And then you're also going to do a lecture.
Yeah.
And what's the lecture going to cover?
So the lecture is maximizing damages. Our practice is one that is not located in a single state. We bounce around wherever wherever our clients need us, we're there. And so I think we are used to jumping into a new state and a new state's law and figuring out how to maximize damages from that perspective. And we've done it recently with some relative success.
Well, I know recently, relative success, I think it was last year. So last year that you got a $100 million settlement in Nevada?
Yeah, last year.
Tell me about how you went about doing that, because that's obviously to get $100 million at one point, you had to turn down 99. So
yeah. So the way we do that and the way that our firm operates is we do that by applying basic trial lawyer practices, really. And that comes from, the way that my mom and dad have orchestrated our firm. We work the case up. We are a freight train heading to trial, applying a lot of the things that I've heard you talk about until and unless we're stopped. So that's the basic principle of how we go about our cases. We prepare for trial. And, this case, it was a tour helicopter crash. The facts are absolutely horrifying. A bright sunny day in Vegas, helicopter crashes, and, our client is on his honeymoon, a 32-year-old guy. Crash happens, and it's not that hard of a landing. Crash occurs. The guy has no broken bones, but the fuel tank does not have what is called a crash-resistant fuel system, which many helicopter manufacturers install as basic equipment. It's like a rubber bladder that stops the fuel from leaking during these hard landing events and causing a fire and burn injuries. The manufacturers have known about this technology since the 1960s. In this case, didn't have it. Despite all these crashes. So, we were able to prove that there was what I've heard people at TLU call a systems-wide failure by the defendants in this case. A complete failure to install a very cheap, widely available technology around this fuel tank that would have saved Jonathan Udall's life. He ended up suffering burns on 90% of his body, and he suffered at UMC there in Nevada for 12 days before ultimately succumbing to his injuries. And we had witness statements who he's crying out for his wife, who also passed, and just the most horrific facts and the most horrific pain and suffering you could really imagine. But it was coupled with the evidence of this particular defendant's punitive conduct, which we alleged and which we were confident that we could prove to a jury. And that was the basic outline of the case. But the way we got it, we kept pushing, man. We kept pushing for trial. We took tons of depositions. We had a ton of experts, and we pushed and prepared the case for trial.
Right. And there was how many other plaintiffs were in that case that did they all die?
So the pilot survived. He lost both of his legs in the fire. And the other passengers all died. We represented the family of one of the passengers. The other passengers hired different counsel and all settled pre-litigation.
And what just to help give us perspective on the difference of, honestly, the difference the right lawyer makes in a case, without naming the names of the firms, but like what were the various settlements of the other passengers who passed and the guy who lost, the guy lost both his legs. What did he settle? Yeah,
I think he settled. I don't know that one, but the other passengers, it's tough because I don't want to badmouth other plaintiffs' firms whom I have great respect for. But look, they did not get $100 million. I think they got, I don't think they got 8 figures. But they settled pre-litigation and they wanted their closure. And that's not what our firm believes in. We wanted, our clients wanted more answers. But, it's tough as a lawyer, when you have good cases, often defendants want to pay quick, right? It's tough sometimes to tell your client early on, hey, I haven't even filed the complaint yet, but defendants are offering $5 million and I have no expenses. And that's a nice paycheck for me and a lot of money for you guys. It's closure and it's hard to turn it down. But, what's the saying? What's the best way to get $1 million settlement, Dan?
Have a $5 million case and fuck it up.
Right. And,
Right.
I'm not saying that these lawyers fucked it up. They did what was best for their clients. But look, it's not the route that we and our clients decided to go. And at the end of the day, it ended up in a different result for our clients.
Yes, different result, much better. And we talked about your case in New York for a minute, but because you sent me a picture that was tried in what court was it tried in New York City?
New York Supreme Court, the ceremonial courtroom of the New York Supreme Court, which was it's badass. It's a badass courtroom. It's pretty cool. And just thinking about the history of that courtroom, I think the Trump trial, the civil one with I forgot her name now, the woman who he was convicted of, I think, harassing or raping. Her name, forgot it, but it's where that trial was recently tried before our case, and a lot of other trials over the years. They got big murals in there, and it was an awesome place to try a 3-month-long trial. It was, walking up those courtroom steps it was badass. It really was.
I can only imagine.
Yeah.
One day maybe I'll get to do it, but one day I'm just imagining it for right now. But which parts of that trial did you do?
So I did the voir dire. I picked our jury, which was a heck of a task because, we had a lot of hardship issues because the first thing we had to tell the jury when they come in is, hey, welcome. We think this trial is going to be 3 months. How many of you have a conflict? So we had to, what we did first was we went through hardships and found ourselves a panel of, I think it was 70 or 80 jurors who then we could do for cause strikes on. Because, with a trial of this length, it's just, if you're going to do hardships and for causes at one time, it would have been a complete waste. So we ended up talking to almost 600 New York jurors before finding our panel. And, it took 2 weeks. Jury selection took 2 weeks. It was a long jury selection. We had our whole team of consultants in the whole time. Picking a jury in Manhattan is a unique beast, man. It really is, especially in 2024. And at the end of the day, we found a great jury. They were super attentive. Manhattan juries are on top of it. They are super attentive. And this jury took pages and pages of notes throughout our trial. And they got it right at the end of the day, which is all you want.
Right. And that verdict was how much?
116 million.
It's a good verdict. And for how many plaintiffs?
1.
So you did the voir dire, and what else did you do? What other parts of the jury?
I did, tons of experts. We had, I don't even know how many experts the defense called, probably 30. I probably did half of them. I did lots of the directs. And it was, we often talked about how many 2 to 3 day trials is a 3.5-month trial in New York City worth. And I don't know the answer to that, but I'll tell you this, it was awesome experience for me as a young lawyer getting in there to get my feet, really soaked during a high stakes trial like this. And it was, of course I did lots of we had tons of motions in limine as well. And the firm trusted me to handle the majority of those, which I'm thrilled with.
Who was your co-counsels on the case?
So our local counsel is this guy named Bryce Moses, who is the absolute man. He is awesome. And we also had another guy named Matthew Schwartz who worked with us. But come trial time, Bryce was there. Great guy. He was there for voir dire, but, the trial was so long that it was just, there's no requirement. A lot of states have a requirement that you have to have a local lawyer present every day. And fortunately, Brittany and me are barred in New York State. We're New York lawyers, even though we have practice in Kansas City. So we were able to kind of be the New York lawyer in the room. So our local counsel wasn't there for most of the trial.
Did your dad try the case with you too?
Yeah. Our trial team was me.
He doesn't count as co-counsel?
Oh, yeah. He's co-counsel, but he's not a New York lawyer.
I didn't narrow my question like that.
Yeah, unresponsive. That's right.
That's
But
right.
yeah, our trial team was me, my wife, mom, and dad. And my dad was lead counsel on the matter. And he did opening and closing.
Yeah. Must have been a pretty cool experience to try it with your family.
Oh, man. Working with family is a privilege. Freaking privilege. I don't take it for granted. I really don't. It's so much fun. And, in our situation, it really works. It really works.
Well, obviously it did. And, I think that probably is a good look for the jury too. And they see, family up there and the dynamic, and it creates a bond. And
So we actually had a funny moment with a juror who we talked to after the trial. So during voir dire, I went, to talk to my wife about, we talking the whole time during voir dire, and I put my hand like on her mid lower back. And the juror after a trial said, God, during the opening of the trial, I thought, like, who is this creepy guy, this poor girl, getting molested by this creep of a lawyer? And he's like very creepily putting his hand on her mid lower back, and that is so inappropriate. First thing we do during voir dire, of course, hey, like, I'm Andrew Robb. This is my, dad Gary, my mom Anita, and that's my wife Brittany. But it's funny, in that moment, he was thinking like, oh my God, what a creep.
the moments in trial that stand out, like, the most for you, what would you say the highlight of that trial for you was, or a moment that happened?
Voir dire was great for me. But as far as moments, I guess I can talk about one moment, which is factual, that occurred. And it was a violation of the O.J. Simpson rule of evidence, which is never, ever, ever manipulate physical evidence in a courtroom unless you know with 100% certainty exactly what is going to happen. Okay? So that's the rule. Without getting into it too in depth, the defendants broke that rule and it came back to bite them. There was an expert they called to the stand. One of the issues in the case, without getting too much into it, is how long it took a cutter to cut passenger harnesses off of them. That was the issue. That's all you need to know. We said it took forever and it was impossible. And it took over a minute. And their witnesses said it took 2 to 3 seconds. That's the background you need. So they roll in front of the jury a mock helicopter seat that the defendants have made, and they have their expert sit down in front of the jury, and he takes off his jacket, he puts on this harness, and he says, everybody, you've been hearing lots about these cutters and these tethers, and, it's real easy. It takes 2 to 3 seconds if you do it the right way, and I'm going to show you. And he sits down, and the defense lawyer takes out a brand new cutter from the box, right? Fresh off Amazon. And he gives it to the expert and he says, Mr. Expert, sir, would you please show the jury how easy it is to cut the tether? And, 20 lawyers are, standing up. We've all gathered around the well, to look, to see like he's going to cut the tether. He's going to do it in front of the jury. This is a big moment in the case. The jury is standing up. They're looking to see like this guy's going to do it. And so the expert, he has a knife and he says, it's real easy. All you got to do is just you got to lean down. You got to apply the knife to the tether the right way, and you cut. And you cut. 10 seconds. And you just got to cut. 15. 30 seconds. He starts to sweat. Silence in the courtroom. The jury is laughing now. The jury is pulled over on the floor. I've turned around and I'm hugging our client because it's emotional for her to see what's happening. And remember, they say 2 to 3 seconds. He's cutting. The only sound in the courtroom, the lawyer's doing nothing, helpless. Their lawyer, right? What's he going to do? A minute. I mean, by this time, it's a clown show. Probably 90 seconds or more. That was their last witness. So after that, they had to get up and say, we rest our case. Stunning. It was stunning. But,
Everything I've learned from all these trial lawyers says you got to try to end the day on a high note.
It was not a high note. Look, it was not.
For you, it was.
Yeah, I'm not on any appellate issues here, but it was a violation of a basic rule of trial practice. You can't do it, and it bit them. It bit them bad. You just can't do that. We have experts sometimes, who insist. You know what, Andrew? I can show the jury. I can do an experiment. I can show why this part failed. I can do it. Just let me try. Our answer is always no. Always no. Because the one time you need it to work, it ain't going to work. Right? And, I have no doubt that they practiced this with this expert. I'm sure he cut the damn thing 20 times. Sometimes, I don't know what happens, but sometimes in the courtroom, justice has a way of revealing itself to the world. And that's what happened. That's what happened.
it did indeed for you.
Yeah.
And so you have to practice in the deposition. You practice in motion hearings. You practice at the grocery store. That's why you have a family. You practice on them. You have to keep the skill up or it erodes. It's simple as that.
Somebody give us an overview of this case.
Or I call wowing it. And what I mean by wisdom of the wise is, why are we still right in spite of this fact?
These are just some of the clips when I was cross-examined 10 years ago, remember that.
About 11 o'clock at night, and he leaves this message. I got a brilliant idea. Every conversation he starts, I have a brilliant idea.
Well, welcome everybody. We've got a good crowd here today.
Andrew, we're going to do a webinar scheduled with you on April 8th on this $100 million settlement. So you talked a little bit about it, but, because our webinars are, pretty in depth. So what else are you going to be covering on that webinar?
Satch Oliver said it best, right? Depositions are a trial. And I think the way that we got this result for our clients and what I really want to teach everyone at TLU to the best of my ability is, how to structure a case through discovery to prepare yourself even before trial to get the maximum possible result. And we do that by really, like I said, applying the basic rules of trial practice, and we press. I think the webinar can cover everything from the way we do our depositions, which I think is a little bit unique. During the pandemic, we really liked over Zoom how everything was pre-highlighted, how you got to, have your documents come up pre-highlighted and everything. So for our live depositions, we have been doing that. We bring in a ton of tech, and it just makes the deposition go so much smoother when, we're able to call up documents and have them pre-highlighted, pre-blown up on a screen for the witness to see. One thing that we really like to do for all of our cases is, I think I can talk about the way in which we prepare. We are not lawyers who believe in really winging it. There are some lawyers that you see who come in and, just kind of, we've all seen them, who look at the documents and they kind of just ask questions based off the documents. We believe in really thorough and diligent preparation for every single witness that we do. We walk in knowing exactly where to go, because I think that allows you to bounce off a little more easily, and I have some really good examples of how that works in practice. I think we come in with an outline. We know exactly where we're going, and so that if we need to divert and dig a little deeper on something, we know where we are in our overall structure. And it starts with getting the jury instructions. That's the first thing we do in every single case, is get a live copy of the active jury instructions, and how to weave in the jury instructions throughout your discovery, which is so critical. And then, of course, when you have a good case, how do you approach mediations? That's something we had to deal with in this case. And our clients were fully prepared to go to trial, and so were we. And I think lots of times in significant cases, defendants always think that plaintiffs' lawyers will just settle, right? I mean, we all know that. They think the plaintiffs are going to settle, and so they have the case structured. They're ready to bill however much they're going to bill on it. And then once they get to that breaking point and they've met their billable target, they say, okay, let's talk. And they think plaintiffs will be like, oh, thank God, you're going to finally pay me money? Oh, yes, I'll take it. And I think when plaintiffs' lawyers don't do that, defense lawyers sometimes get a little thrown off, right? So in this case, there was no mediation requirement in Nevada. Lots of states these days have a mediation requirement, right? We, with our clients' approval and encouragement, did not want to mediate. We said, no, we're not going to mediate. We're ready to try the case, and that's what our clients want to do. And we and our team is prepared to go to trial, and we refused. And so what the defendants did is they filed a motion to compel mediation. And so I can talk about how to deal with that. It's obviously a pretty good problem to have if you're getting to a point where defendants are begging to have the glorious opportunity to sit down with you so they can pay you, right? But, that didn't just happen. That was a result of, I think, the work that we put in to this case over many, many depositions and lots of discovery. I'm anxious to share that with your TLU people.
And so you did go to court order mediation,
Yeah.
and it didn't resolve at mediation. But
Right.
how much did you turn down at mediation?
Oh, God. I don't know exactly, but I do remember whatever we turned down would have been the record for the single highest wrongful death settlement in American history at that time. So it must have been over 70. But, we believed in the case.
Obviously.
Once they got us to the table, they thought that it was over because our clients were not from America. They were English clients. And the court required it to be in person. And so our clients flew from London to Vegas. Long flight, right? The defendants were like, okay, the clients are not going to come all the way from London to Vegas for a court-ordered mediation and go back without settling, especially when we're going to pay them all this money, the record settlement for any wrongful death case ever. And we did. And I think that really surprised them. 2 months later, we had motions in limine hearings. We had probably 150 motions in limine. And it was in January of last year. Trial is set for, I think, February 4 or 5. And there were 2 days of motions in limine hearing. And, talks kind of started during motions in limine and ended up resolving on the second day of motions in limine for $100 million.
Wow. And speaking of Vegas and Satch Oliver, so we're not doing a Vegas conference in 2025. So if you want to come to TLU in 2025, it's going to have to be where Andrew Robb's at in Huntington Beach, June 4th through 7th. But there is an opportunity to come to Vegas on multiple times, but one with Satch Oliver and John Romano, because April 1st through 5th, we're doing a depositions and damages boot camp. So Satch is going to be working with people on the stuff you talk about, putting together their depositions, especially the 30B6 on trucking cases, and how he goes about applying his methodology to extract the information to build his trial story around it. And then John Romano is going to be helping people put together their damages story. And then in between, that's just half the time. But the other half of the time, myself, I'm going to be working with people and training them on the presentation skills, on the hand movement, eye contact, voice control, emotional state control, glance control, creating spaces, all the nuances of presentation and connection that most people, frankly, are not familiar with. I mean, they're familiar with them, but nobody's ever, practiced, trained, or studied them.
Totally.
And so people will be bringing their actual cases and working those cases for 5 days. We're also going to be doing, witness prep and direct examination training too. And it's limited to 10 participants. So it'll be, 5 students in each group, and they kind of stick together for the 5 days. So that way everybody's familiar with each other's cases. And your case is going to get exponentially better.
Yeah.
You're going to get a great network of, great, Satch and John. They're both like, John's a legend. Satch, is a really probably already legend. I mean, he wrote a book that's very popular, and he's gotten a lot of 7, 8, 9 figure, results already. He's only 43 years old. So, and I'm so psyched about it because, and it's all case expense, because you're making your case so much better.
Preparation, right? You've got to prepare these cases, and what a great thing that I think you're doing, and having these people really think about their cases from all these different perspectives, and it's going to make their cases better.
Right. And then there's 5 Zoom meetups ahead with Satch and John and myself, where you're going to be, actually, working on the substance of the cases and the parts of the cases, the deposition setups and the damages setups and the presentation skills. Because people, presentation is a skill.
Oh, yeah.
And you have to practice it. And so we do a lot of drilling and practicing before anybody gets to Vegas. So that way, when they show up, they're just that much ready. We're ready to go. It's not people, so many times people show up to like I went to the trial lawyers college for 12 years in a row, and there was no structure there. It was just like, whatever you felt like doing, we'll do today. And it was, and it was fun. I made lots of new friends, but I don't think it helped me become much of a better trial lawyer. And from, the 12 years I spent there, I didn't see people get much better. And the people that were already great, they were already great.
Right.
The ones that weren't very good, they actually, they weren't just very good, but I think they actually got worse because they spent 3 weeks thinking that they're learning all this, whatever it is these great trial lawyers do. And then they step into a courtroom, get shellacked, and they're like, oh my God, I did all this effort and did all this stuff. And, it's still not working. I still can't, I'm no better.
Yes.
And, because to learn a skill, you have to have repetition. You have to have instruction on how that skill should be performed. It's like, golf, right? You're a golfer.
I am.
You're right. And so, you're taking golf lessons. I imagine you just weren't naturally born golfer.
That's
Nobody
right.
is.
Yeah, you got to prepare, right?
Well, the first thing they teach you to do is how to hold a club,
Yeah.
right? And then how to stand,
right?
Then how to twist your torso so that you're not just swinging with your arms, but your whole upper body's moving, and so that you have a consistent swing. And then they record you, and then they play it back for you and show you where you're messing up. And then you have an instructor who gives you a practice plan. And then you go to the driving range and try to apply what you just learned. That's how you learn a skill. You don't learn a skill by watching Tiger Woods play.
Totally
That's
agree.
not how you learn. And so that is what we have to offer in April 1st through 5th. There's still 4 spots left. I know it's amazing. To me, it's amazing because there's only 10 people. That there's still 4 spots left, but it's going to be fucking awesome.
Love it.
And then, do you go to many conferences outside of like AAJ?
Yeah, we do AAJ. We do our state bar conference, and not so much ABA anymore, but AAJ, MATA, TLU.
All right. Well, I'm going to Panish. Panish does a conference up in Ojai. It's at the end of end of February. The PSR conference. I went a couple years ago. It was in Deer Valley. It's a really great conference. They really spend money on the conference. Of course, they have a lot of money to spend, but it's a really great time, and they really put together. Explain the philosophy.
Lucas will be there too, huh?
Spencer will be there because you worked on Spencer with the on the Kobe case. Is that right?
Yeah. I did. They had some other passengers in that case, but man, Spencer is a great guy. Really like him.
He is a great guy. I met him in 2016 because I used to teach this program called Trojan Horse Method, and Spencer came as came to it obviously as a student, and like I didn't know who he was. I knew he worked at Passions, but other than that, like the guy had already had like several 8-figure verdicts by that time.
Oh, I know.
And the fact that a guy is that kind of results, but still learning. And I worked with him in Passion a little bit on, they got a $135 million sex abuse verdict out. Can't remember the name of the county, but Riverside last year. So I worked on with that a little bit on their, doing some focus groups and stuff.
They're studs, man. They're studs for sure.
Yeah. So that's really great. And then I am going to be teaching on cross-examination of experts, but just like at this motorcycle summit down, it's in Orlando. It's a NTL production. But anyways, so that I'm pretty excited about too, because it's kind of fun to teach.
Yeah.
Obviously I get to teach at my own conferences, but teaching other conferences is pretty fun. It's a different group of people because, I really put, one of the things that I think is really one of the most valuable things that we've developed or I developed with other people is like this cross-examination methodology of experts because it's the defense method. Because I think the key skills to be gleaned in cross-examine or to be mastered are, obvious ones are leading questions only, right? One two-factor question. But, but looping. Most people don't loop, obviously establishing a fact and repeating it. Like cross-examining in the present tense, which forces you to visualize what you're talking about, forces a witness to, but more importantly, allows the jury to actually picture or visualize what you're talking about.
Yeah.
Dropping the taglines like right, correct, isn't it true?
Every time.
If you can't drop those, at least leave some space between the statement and the tagline. So it's like obviously they're used for control, but dropping all the filler words like and, so, okay, which not just, most young lawyers do that stuff because they can't handle the silence, but even experienced lawyers of 20, 30 years are still putting all that crap filler in there.
It's hard.
Effectively using a flip chart, to anchor your points, just putting one concept per page, writing legibly, using glance control to, get the jury to look where you want them to look. Those are key skills. Being intentional with the pace of your voice.
Yeah.
Because most people speed up. Like you said, we talked about earlier, don't breathe, especially on cross. As soon as they say cross, it's like, "Rrr," and then it's like, like they speed up, they don't breathe, their words run together, the jury can't quite understand it. And, but along with that is being intentional with your emotional state. Like I really think there's only 2 emotional states in cross-examination. One is curiosity, like when you're doing foundational cross, when you're setting up the expert.
Yeah.
And the other one, when you impeach them, is disappointment.
That's right.
Isn't it sad that you went to medical school and you took an oath to help people, but you decide, what?
You can't even tell the truth, right?
Right. You decide to sell your soul to the insurance company for money. Like, so sad to be you. Those are really the key skills. And also
you do video impeachments? Talk about those.
I don't do that in the training, but those are critical and setting those up and practicing them.
Oh man.
Right.
Those are awesome.
every impeachment, though, people often don't practice their impeachments before they get into a courtroom. And then,
Yeah.
when you have a good impeachment, but you along, a minute delay between the impeachment and showing something, it really loses steam and doesn't, I don't think it makes the lawyer look well prepared. And,
Oh, man.
So that's just,
Talking about
we don't teach that because we only have limited time.
Yeah.
But that's, a different class at some point. But anyway, so that's what I'll be teaching about at the Motorcycle Summit. John Romano's teaching there, Drew Ashby. There's some great lawyers teaching down there. And I was at it last year in Savannah. It was it's a much smaller conference, maybe 150 lawyers.
Everyone learns a lot there, I'm sure.
Oh, yeah. And it's, I'm putting, working on motorcycle cases, getting motorcycle cases. So it's pretty fun operation. I like conferences, get to meet a lot of new people.
For sure.
Expand your social circles, all this kind of stuff.
But man, that video impeachment stuff, it is so effective. We did a ton in our trial in New York this last summer. And there's a way to do it, right? You got to have the exact word for word impeachment. And then to be able to show the jury the person's face saying the exact opposite of what they just said, instead of going, could you read lines 4 through 7 of your transcript, sir? And then, oh, really? I can't read this. Which lines was it? It's just so effective. And the impeachment, the question on the impeachment is not, did I read that correctly? It's, was that you on the screen?
I could agree with you more.
Yeah.
I mean, anybody that's doing depositions and not doing video depositions, I think it's just nuts in today's world.
Yeah.
Because the power of it is that when they testify, people default to truth, right?
Yeah.
I mean, unless Trump's talking, people default to truth. If he's talking, you have no idea. It's about maybe 40% likelihood that something's going to be accurate there. But the reality is that most people believe, especially they take an oath to tell the truth.
Yeah.
And it's supposed to be under the penalty of perjury, which is why Trump never testifies in any trials or any courtrooms, because he's,
the perjury machine.
Right. Not because he never goes under oath, so he can't really be getting big perjury. It's just, nonsense, nonsense after, lies after lies. It's like, this recent one is that, let's see, Zelensky started the war.
Yeah, he's a dictator now, right?
He's a dictator now, right? All this nonsense. It's like, what world is this guy living in? But unfortunately, he's living in our world, and we're bearing the consequences of these things. But that's another conversation. But the beauty of the video impeachment is, I think the real power is when people see that, they hear it, they believe it, and then they see the opposite. The person looks the same. Now they recognize that they can't really believe anything the person says because they look the same when they're lying as opposed to be telling the truth. Well, we don't know if they're lying or telling the truth because most people, when they lie, it has a physical effect on them. They look different. They get, but for people that are sociopaths and just lie through their teeth, like a lot of these experts are, because they're so trained at lying, they look the same. And I think that's where the power comes in with
Totally agree. Talk about what you said about disappointment when you're impeaching. It is so effective to look at the screen while the impeachment's happening, and then you look back at the witness and you just shake your head. Was that you? Give her the exact same answer. It's the question I just asked you, Mr. Expert. It's just like, I feel that. So it's so true. It's disappointment. Didn't you swear to tell the truth? I mean, come on. You gave that exact answer to the question I just asked you. And that was, 8 months ago in your deposition? And you swore to tell the truth then, just like you did today, right? I mean, it's just so effective.
Yeah. All right, Andrew Robb. This is going to be the end of our visit here until April 8th and our preparation beforehand. Oh, let me just say, if anybody needs to get a hold of me for anything, my email is dan@triallawyeruniversity.com. My cell is 248-808-3130. If you miss Andrew's presentation on our webinar, everything's recorded that we do, the last 4 years of conferences. We just did our 401st webinar yesterday, and our 400th one before the Joe Fried's breakdown of his Amazon verdict was our 400th webinar, appropriately. But anyways, all those have been recorded, and we have all the pleadings, transcripts, and PowerPoints for all those cases. So if anybody doesn't have TLU on demand, and it's also an app for your phone, and wants it, they can get it. I mean, if you shoot me an email or a text, I'll send you a 30-day complimentary access so you can check it out to see if it's something you're going to be used. Because we're all trying to get better every day, right, Andrew? Andrew, I forgot to ask you, what are you doing? What do you do on a daily basis to try to become to work on becoming a better trial lawyer?
Great question. Like I said, I think a lot of us are complete addicts. What that means is I think you got to, one thing that really, really do is immerse yourself in not just your own work, but learn from your colleagues. And what that means is, someone gets a great result, take them out to coffee. And we do that all the time. Someone gets a great verdict, you call them up, man, what a great result. You celebrate with them, you take them out and you hear about the case and you learn from what they did, right? Because I think it's obviously very arrogant for any of us to think that we have all the answers in our own little worlds, in our own firms. And I think, being a good trial lawyer requires a high degree of humility in some degree and the willingness to say, hey, there's a lot much more that I can learn. And there is so much great content coming from, all these different platforms, right? People, different webinars, different listservs. And at the forefront of that is what you're doing here, right? And so immerse yourself in that content, but also, talk to people who are trying cases, not just your own. And I found it so fascinating to sit from an outsider's perspective as some of my colleagues just recount their trial stories to me and learning about what they're doing and taking that in and taking it back to apply some of our own cases. And I think that helps make us all better lawyers.
I agree. And that's why I started doing, this platform, because I get to pick the brains and dig deep into the verdicts of, some of the greatest trial lawyers in the country that, many of us have heard of, but there's so many great trial lawyers out there that people have never heard of because they just get verdict after verdict, but they don't go on social media. They're not got pictures of themselves on their jets. They're not, constantly just doing, self-promotion, which I think is really important to do, self-promotion, because in today's world, if you're not promoting yourself, well, cases that, you might be best suited for are going to go to somebody else. Just the world we live in. And they might eventually trickle their way back to you, but then you might, then you're giving away a big chunk of referral fees sometimes too, which is the way the business works, obviously, right? Typically the top lawyers aren't doing billboards. They're not, they're not doing pay-per-click. They're just, mostly getting cases from other people that get them that recognizes a specialized skill. What percentage of your firm's cases come from other lawyers?
That's the name of our game. A lot of attorney referrals, and a lot of times people just get online and, they need an aircraft accident lawyer and they find us. But
right.
Attorney referrals are a large part of our business. People get aviation cases and obviously, like you said, specialized field, super unique stuff going on in all aspects of the case from top to bottom. And, people want an expert in the field, and that's where people find us.
Right. And so how do people get a hold of you?
My email, acr@robrobb.com. My cell, 816-547-5229. That's how to get a hold of me.
Or they can meet you in person at TLU Huntington Beach.
I'll be there.
Connected person, which is always my favorite way to connect. All right, Andrew, it's freezing here. Oh, on a side note, I'm at the Ritz-Carlton at this conference.
Yeah.
And I got trapped in the elevator today for 20 minutes.
Oh, no.
It was literally 35 degrees in the elevator too. I was on my way to go down to work out. And I'm calling the people and they're like, okay, which elevator are you on? I'm like, how the hell would I know which elevator I'm in, right? One of 4 or 5, but you can't tell where these things are stuck at. And I kept thinking about if the elevator dropped, because I hear about these drop elevator cases.
I know. They happen.
Right. And then and then I'm thinking, fuck, I've got my spine. It's been good for 57 years. Some of my friends have back surgeries, back injuries, from car crashes. I'm like, shit, if this thing, because it did drop 2 feet, before it froze, it scared the crap out of me. But
yeah, this is how you're going down, an elevator at the Ritz-Carlton.
But eventually I got out. So I was almost a tortfeasor, but although it was pretty traumatic, I'm a little nervous in the elevator, especially at this hotel. I'm I celebrate making it to a floor now. Never experienced. You appreciate things differently when you had some traumatic experiences. But
I hear you.
Just wanted to share that little side note before we take off here. All right, Andrew, Robb, you take care. We'll see you soon.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.